Good morning. First filed in this courthouse behind me, Emily Doe's 12-page letter written to a judge and addressed to her attacker started a revolution. Since then, her words have been read by millions. It started a revolution of empathy and understanding. It has given solace to women who have suffered their own sexual assaults in silence. It has inspired tears at her struggles, admiration for her honesty, strength, and perseverance. It sparked fury and frustration at those who continue to misconstrue these assaults as sex gone a little too far, or who blame and shame the victims. It has exposed those who continue to cast these assaults as something lesser, something other than a brutal smash and grab of someone else's dignity. Her letter left us a painful yet powerful gift that demands something more than just a few minutes of our time. It demands change. I have stood on these steps 2 times before. Once when the jury's verdict was announced, and once when the defendant was sentenced. Today, I stand here for a 3rd time to announce change. Joined by Assembly members Evan Lowe, Bill Dodd, and Senator Jerry Hill, and a growing number of legislators, we are hoping to change hearts, to change minds, and to change the law to protect the next Emily Doe against the next Brock Turner. Much of the outrage over Emily's case has revolved around the sentence. The judge gave the wrong sentence, but he had the legal right to give it. So we'll start there. Why, under the law, is a sexual assault of an unconscious woman less terrible than that of a conscious woman? Is it less degrading? Is it less tragic, less traumatic? The fear and terror that accompanies the absence of memory of a sexual assault victim should never be viewed as less serious than the fear and terror that a victim experiences during a recalled sexual assault. Is a man who intentionally targets a woman because she is so vulnerable any less a predator? The law as currently written makes clear that a defendant's use of force will trigger a mandatory prison sentence. Of course, when a victim is too intoxicated to give consent or is unconscious, the victim is unable to resist, and the perpetrator does not have to use force. So a perpetrator at a college party who chooses to forcibly rape a conscious victim will go to prison. However, a different perpetrator at the same party who chooses to watch and wait for a victim to pass out from intoxication before sexually assaulting her can get probation. Our proposal would change the law so that sexually assaulting an unconscious or intoxicated woman would be probation ineligible. This means if you are convicted of sexually assaulting an unconscious or significantly intoxicated woman, you go to prison. This means that a judge can't look at relative youth, nominal criminal history, and means, characteristics shared by many college students, as mitigating factors and give probation and a slap on the wrist to campus rapists. Convicted rapists, whether they committed their crimes on campus or off campus, whatever racial or ethnic background, rich or poor, must be sentenced to prison. Rape is rape. Let me quote from Emily Doe's letter. The seriousness of rape has to be communicated clearly. We should not create a culture that suggests that we learn that rape is wrong through trial and error. The consequences of sexual assault need to be severe enough that people feel enough fear to exercise good judgment, even if they are drunk, severe enough to be preventative. I can't tell you how much I agree with Emily Doe, and I call on every state legislature in California who shares this view to join me. We've read her letter. Now let's give her back something beyond worldwide sympathy and anger. Let's give her a legacy that will send the next Brock Turner to prison. Let's give the next sexual assault victim no reason to fear that her attacker will be walking around free after spending less time in jail than a college semester. Emily Doe sat down and wrote a letter that started an international dialogue. She showed us the need for change. Now, what are we going to do? It's on us. Thank you. We'll take a few questions. Yeah.
You said that you could change the penalties for rape of an unconscious victim. Mr. Turner was convicted of sexual assault, not rape. How would your legislation apply to those kinds of counts?
What this legislation does is the penalties for sexual assault of a conscious person, which would have been mandatory prison in this case, we would then have the same consequences for sexual assault of an unconscious person, meaning mandatory prison.
What is the minimum prison term? Is there one?
Yes, the minimum prison term for sexually assaulting a conscious person or an unconscious person would be 3 years. It's a 3, 6, 8 offense. 3 for the low term, 8 for the high term. And so what this law would do would say to judges that sexually assaulting an unconscious person is prison. And then if you want to decide, judge, whether it's 3 years, 6 years, or 8 years in prison, then you can look at factors like prior criminal history or whatever you want to look at, but that's the range. Probation would no longer be a possibility, and you wouldn't have a situation like we have now where this person commits a horrible sexual assault and spends less time in jail than a college semester.
I have 2 questions. First of all, are you interested in changing the definition of rape to include all forms of penetration, as some people in Sacramento want to do? And secondly,
so I haven't taken, I've heard about that legislation. I haven't looked at it carefully. I think there's some merit to it. I think the advantage of this legislation is it would ensure that rapists like Brock Turner would go to prison. Changing the definition of rape is something that's helpful, but it wouldn't actually send people like him to prison.
walk us through the steps of what it would take to actually change the law.
Well, here. Step 1, we filed charges against Brock Turner. And we were able to file those charges because 2 Swedish graduate students were upstanders, intervened, saw something that was wrong, and did something about it. And we're grateful to them. Our fantastic prosecutor, Alaleh Kianerci, took this trial here in this courthouse in Palo Alto, and a jury unanimously convicted the defendant, Brock Turner. At that point, we asked for a prison sentence of 6 years. As everyone knows, the judge in this case gave 6 months, and the defendant only asked to serve 3 months in jail. Too light a sentence. We spoke with Emily Doe after the sentence, and we said the letter that you wrote was so powerful, and reading that letter in court was so eloquent and incredible. Would it be okay if we released that letter? And she said yes. We scrubbed some of the redactions to protect her anonymity, and we released that. And I must say that our hopes at the time were quite modest. We attached the letter to our website at the DA's office. We hoped that a local media outlet, a newspaper or a TV station or a radio station might link the victim's letter to their website, and maybe a few hundred or a few thousand people would read it. We and Emily Doe are overwhelmed with what has happened. And that came back to us to say, well, what are we going to do now? So, number 1, we're proposing this piece of legislation. It's AB 2888. And it's a bill that Assemblymember Lowe, Dodd, and State Senators Hill, and I believe many state legislatures will support. It needs to be passed in the Senate and the Assembly, and then goes to the governor's desk for signature. I know that there will be hearings about this next week, and Deputy District Attorney Kianerci will be going to Sacramento to testify at those hearings. And we are hopeful that this law will be passed. And the reason that this law is important is it reflects a raising of our consciousness as a society. What this law reflects is saying that sexually assaulting an unconscious person is as serious as sexually assaulting a conscious person. And there should be no distinction between those, because rape is rape. And for a long time, let's be honest, for decades, what happened on college campuses on Saturday nights was overlooked and swept under the rug. And after that happened over decades and decades, there's a certain anger that has boiled up in our society and around the world. And I think this legislation that we are proposing is a positive step to recognize the awareness that we have about sexual assault, something that will help to empower sexual assault victims and survivors, something that will deter criminals and perpetrators, and something that we hope changes people's views about what to do in situations like this. We've had a change in our society about how we view drunk driving, and everyone knows to have a designated driver or to take a taxi or some other service. I think this legislation is helping us have a conversation to encourage upstanders, encourage people to intervene and get involved, and also to recognize consent. That person's unconscious, that's it. Nobody's going to touch her the rest of the night.
How does it currently read? So there is a statement sexual assault or rape of an unconscious woman versus a conscious woman?
Yes, currently the sexual assault of an unconscious person, the perpetrator is eligible for probation. However, the sexual assault currently of a conscious person is not eligible for probation. It's mandatory prison. And so what this legislation does is it makes these equal and says sexual assault of an unconscious person would also be ineligible for probation and a prison sentence, just like sexual assault of a conscious person.
Jeff, given the present state of the law, is it you're feeling that legislation is needed because we just can't leave this in the hands of judges?
I think that, sure, I think that the need for this legislation is illustrated by what happened in this case, where a judge made what I believe was the wrong decision and gave this predator probation when this person should have been sent to prison. And this law will still allow judges to have discretion. It's just that the discretion will be how many years in prison. Is it 3 years, 6 years, or 8 years? And it removes the possibility of probation. Because, look, if someone can get probation for having relatively little criminal background, if any, for having a record of accomplishment in their life, and for coming from a good family with a lot of support, then really what that says is college rapists aren't going to prison. And that's wrong. And people know that's wrong. And that's why they want to change this law.
Do you know of other states that have similar legislation in place similar to what you're proposing?
I'm not familiar about other state legislation, so I don't know.
Are you formally co-sponsoring this, or just lending your support to it?
This is something that we wrote in the DA's office, and then we reached out to Assembly members Lowe and Dodd and State Senator Jerry Hill, and they are the ones that introduce it.
Today?
I'm sorry?
The probation department also recommended this. Would this also change the way that they're handling?
Yes, this would also change what the probation department's recommendations would be, because in the future the probation department will not be able to recommend probation in a case like this. They will be choosing whether it's 3 years, 6 years, or 8 years in prison.
DA Rosen, there's a recall movement going on, as you know.
Yes.
And I interviewed one of the organizers of that movement yesterday, who said essentially that the law does not need to be changed. What needs to be changed is the judge. Have you changed your position on removing the judge?
No. I believe in judicial independence. The judge got it wrong in this case, but he had the right to give that sentence.
Are you going to seek the Attorney General's office?
What's that?
Are you seeking the Attorney General's office when Kamala Harris vacates it?
No, I'm currently serving as the District Attorney of
And
Santa.
you're gonna stay-
Let me finish my sentence?
Sorry.
I'm currently serving as the District Attorney of Santa Clara County. I enjoy it. I like serving this community, and I'm running for re-election as District Attorney of Santa Clara County. And you can visit my Facebook page.
Do you foresee any future problems with having Persky on the bench? You've already removed him from one case, and him being able to hear cases with how much media attention this has brought on him?
So we will look carefully at every case. We look carefully at every case that's sent to every judge in our county. So we have 40,000 criminal cases that we file a year. It's very rare that we challenge a judge and say we don't want a judge to hear that case. All of those challenges are signed off by me personally in the office, and there's maybe 4 or 5 a year that we do at most. It's a very low number. Having said that, we will look and see what cases are sent to Judge Persky and every judge, and if we have a reason to think that the judge will not be fair in that particular case, then we will file and remove the judge from that particular case. I don't know if that is going to, I just don't know what cases are going to be sent to Judge Persky. I don't know what his assignment's going to be, so it's hard for me to predict the future. I'm very good at staying in the moment and talking about what happened. I'm not so good at predicting the
Have you
future.
talked to the judge at all after this?
Have I talked to the judge?
Any kind of conversations?
No.
So are you actually discouraging voters from signing a petition to recall the judge?
The great thing about this country is the First Amendment, and one of the great things about this country, and people have the right to disagree. So while I support judicial independence, and that's an important value, accountability is also an important value in a democracy.
Have
you
you
think
talked to
it
the
should-
victims?
should it be made-
Support?
Any kind of legislation change?
I'm sorry?
Legislation?
I
Is this
did-
unusual for your office? Have you ever done this before?
We have supported changing legislation in the 5 or so years that I've been the district attorney, so it's not, it's something that every year we bring proposals to the state legislature to have certain laws changed or amended. I'd say we probably bring, 5 or more to the state legislature. I think what's maybe a little unusual about this situation is just there's tremendous amount of attention around this particular case, because I think the public understands that an injustice was done here. And they understand that if you have a situation where, my God, 2 people saw this terrible thing happen, a jury convicted, and this poor victim cooperated with the police, testified at the trial, spoke at the sentencing, and I think what really bothers people and hurts them and makes people feel sad is the sense that the victim was not heard in terms of this sentence. And I think what's ironic here is that although the victim may not have been heard in terms of the sentencing, since then, she's been heard all over the world.
Should it be made known that the judge always followed the probation department recommendations according to a recent AP story, and this was completely in line with that? Should you mention that when you're asked about the recall, sir?
Well, I have read that the judge usually follows the probation department's recommendation. I think what's important for people to understand, and I think what citizens understand, is judges are appointed or elected, and the judges make the decision in terms of sentencing. So whatever the decision is, that's the judge's. And whether probation recommends X, Y, or Z, it's ultimately the judge that makes that decision, and no judge should be a rubber stamp for probation.
A couple more questions, guys.
It sounds like you
What
want
about as far as the
to,
victim?
closing the.
One second, here and here, yes.
Have you talked to the victim? Is she in support of this? And is there any talk of a civil trial against Turner by the victim?
So Deputy District Attorney Alaleh Kianerci has been in contact with Emily Doe, and she supports this legislation.
What about civilly?
That's her decision. We don't handle civil cases, so that's entirely up to her.
Sounds like you have a little bit of a nuance.
One second, yes.
So it sounds like there's a kind of closing loophole here, unconscious versus conscious people. Is it, I think most people would be shocked by that. Is it sort of, just look ahead, but is that sort of a loophole?
I think that the legislation that we're proposing changes a loophole, you could call it, between sexually assaulting a conscious person and sexually assaulting an unconscious person. And it makes the penalties for sexually assaulting an unconscious person the same as the penalties for sexually assaulting a conscious person. And I think people understand that and support that because, after all, what is the difference between those two? The trauma to the victim, whether conscious or unconscious, is often lifelong. Yes?
I'd like to give a little bit of a nuanced position with respect to the recall. While you're not in favor of it, you're certainly not discouraging voters from signing the petition. I mean, is that fair to say that if you were faced with the choice at the ballot box yourself, I mean, how would you vote?
I think ballots are secret, right? So let me just reiterate, I believe in judicial independence. That's an important value. Certainly in a democracy, accountability is also an important value.
Won't this leave all power in the hands of the district attorney to decide whether to charge a higher charge or a lesser charge?
Thank you very much.
Thank you very much. Thank you. Thank you all.
Thank you, gentlemen.